Okay, thank you very much for this kind introduction. So I will just go ahead. I will read my talk in order to get everything across which I want to get across. So this presentation is based on two foundations. First, I have been concerned with questions of transitional justice in Somalia in the context of several research projects, which already were mentioned over the past years. Second, I was involved as lead analyst in a consultancy directed by the Somali Stability Fund on assessing the scope and parameters of transitional justice in Somalia last year. The Somali Stability Fund is a multi-donor fund that, in its own words, supports peace research in Somalia. Its resources come from various governments, including the Netherlands, Denmark, Norway, Sweden, and from the European Union. For this consultancy, 73 semi-structured interviews were conducted by a small team of Somali researchers in 5 locations of south-central Somalia, between Kismayo and Garowe. The interlocutors were partly members of the political and business elite, partly others, including internally displaced persons, civil society activists, academics, and a few active ex-fighters, including several men who were close to Al-Shabaab. Most of the interlocutors were between 30 and 60 years old. Around 1/3 of them were women. All interviews were conducted in Somali and later summarized in English by the team of local field researchers on the ground. The questionnaire included around 30 questions centering around topics of past experience of violence, what already had been done to deal with these past experience of violence, about conceptions of justice, obstacles for reaching justice, and the force. The field research took place between August and September 2021. Once I had received all of the interview summaries, each between 3 and 8 pages, I started using Atlas TI to code them. And eventually a report was published in November 2021 by the Somali Stability Fund, which summarizes this research. Then the following I draw on these two foundations, my earlier engagements with transitional justice in general, and this most recent field research data, which I could analyze to reflect on the usefulness of established approaches to transitional justice in settings of ongoing conflict, discuss options and challenges of transitional justice in Somalia based on the legal plural conditions prevailing in the country, and ask how Sharia would fit into the process of dealing with the violent past in Somalia. Now I will talk a little bit about the transitional justice genealogy. This is a term which was established by Ruti Teitel in a quite famous book on transitional justice genealogy and published in 2000 or 2003, I think. The concept of transitional justice is usually traced back to the Nuremberg Tribunal after the end of the Second World War. The foundational idea was to make it clear internationally that certain crimes were so horrendous that national sovereignty and national laws could not protect the perpetrators. The second foundational idea was that to move from illiberal rule to democracy, those responsible for the worst past crimes must be held accountable. This, however, immediately produced a foundational dilemma that began in Nuremberg and continues until today. At the heart of this dilemma lies the question, to what extent transitional justice is guided by conventional notions of the rule of law and individual accountability associated with established democracies, and how many exceptions have to be made. So on the one hand, you have an established justice system in which all kinds of rules apply, for instance, nulla pena sine lege, so no punishment without law. And in transitional justice contexts, many of these established rules have to be bended or have to be, so to say, put out of order for a certain time in order to punish perpetrators, even for crimes which were not illegal in their own national legislation when they committed them. So Teitel points to the exceptional character of transitional legal arrangements as opposed to conventional legality in democracies at times of peace. So she asks, what are the relevant legal orders? Is the entire project ex post? So is this, so to say, an ex post legislation which is normally in legal thinking not allowed? Who should be held accountable and for what offenses? One basic distinction about possibly applicable rules and norms concerns restorative versus retributive forms of justice. So restorative forms of justice aim at restoring social harmony, for instance, by exercising forgiveness, and retributive forms of justice demand individual punishment for the crimes committed. Much of the established transitional justice literature argues that without addressing past injustice and holding perpetrators accountable, sustainable peace, democracy, and development cannot be reached. So this is basically the basic assumption of much of the established literature. In her influential genealogy of transitional justice, Title characterizes transitional justice since the 1990s and until the present as a steady state of transitional justice. So there are certain, phases starting in 1945, but what we currently have is, so to say, the third phase or the third stage of transitional justice, according to Title. And it began with the new humanitarian interventions after the end of the Cold War and led to the normalization of transitional justice as part of post-conflict reconstruction packages today. It involves a partial return to the Nuremberg principles as exemplified by the creation of the International Criminal Court in 2002. Also, the tribunals for Rwanda, former Yugoslavia, and the Special Court for Sierra Leone go in the same direction. So on the one hand, you have, this kind of establishment of legal institutions adjudicating past violences in places like Rwanda, for instance. But on the other hand, you also have an increasing emphasis on restorative forms of justice, which have been used, for instance, also in the context of the Truth and Reconciliation Commission in South Africa, where truth-telling was becoming very prominent, which is one form of restorative justice, but which also has been used, for instance, in Rwanda, in the form of the so-called Gacaca courts, which integrated so-called customary forms of dealing with crimes or violations, but also in northern Uganda, where certain traditional, in inverted commas, traditional elements of forgiving perpetrators and reintegrating them into local society gain prominence in regional transitional justice processes. So an interesting question, at least for social anthropologists, is what about normative orders that largely disregard individual accountability, for instance, under Somali customary law? What about spiritual conceptions according to which justice can only be done by God in the hereafter, as many Muslims in Somalia argued, Muslims in Somalia argued? Another question is how transitional justice and state building can go hand in hand in a context of ongoing conflict. Related to that is the question how much state infrastructure is needed for a successful transitional justice process. And finally, if conflict is still ongoing, does transitional justice contribute to conflict settlement or prolong the fighting? So these questions are relevant regarding the current cases of Libya, Syria, Afghanistan, but of course also Somalia and Ukraine today. So this is, so to say, kind of a quick overview over some of the established literature and some of the questions which are relevant, I would say, regarding transitional justice processes today. Though another discussion concerns the localization of transitional justice. In the last decade, literature paid increasing attention to the limits of transitional justice as conceptualized so far. In this context, anthropologists, among others, have focused on local conceptions of justice, weak state institutions, the role of legal orders beyond the state, layers of violence and injustice by a multitude of different actors over long periods of conflict that are hard to address, and what all this means for transitional justice projects on the ground. In a seminal volume on localizing transitional justice from 2010, Shaw and Waldorf advocate a bottom-up perspective on the study of transitional justice. Such an approach considers the ways in which transitional justice mechanisms are challenged, resisted, instrumentalized, and reconfigured in local engagements. The authors also emphasize that the current ubiquitous call for respecting indigenous next to national or international approaches to justice is misleading. So I mean, in the literature, there is some concern that we have a reconciliation between international norms and indigenous norms or conceptions of justice. And even in a famous UN document from 2004, the then General Secretary of the United Nations, Kofi Annan, mentioned that transitional justice means also to include indigenous forms of law or justice. However, anthropologists, of course, would mention that in many cases, indigenous forms of justice are not in harmony with international conceptions of justice. Moreover, the question is to which degree legal decisions can be enforced on the ground in fragile political settings. It is also clear that local justice processes, which based on whatever normative orders are available, involve specific risks. Under so-called customary or religious law, for instance, women, youth, or minorities might be structurally disenfranchised. In some cases, especially in politically volatile situations, keeping silent rather than telling the truth is appropriate to secure individual survival and/or social cohesion. Individual accountability may at times be less important than the establishment of social morality. Ex-combatants in Sierra Leone, for instance, used public testimonies not to admit past deeds or crimes, but to present themselves as acceptable members of the community at present. So the issue was not so much what they really have done, but how they could be reintegrated without really accounting for past crimes. In situations of mass violence, victims and perpetrators may trade places from locale to locale or over time. In Somalia, for instance, some militias first evicted certain clans from certain areas. The latter then formed their own militias and cracked down on other weaker groups, evicting or enslaving them. Complex layers of local histories of violence need to be considered in a localized approach to transitional justice. Finally, questions of space and related to that physical coexistence and separation impinge on people's preferences for either retributive or restorative justice. Those who have to live together after violence and in one place as intimate enemies may prefer restorative mechanisms, including amnesty, while others who reside in seclusion or who enjoy security in the diaspora may demand retributive mechanisms to hold perpetrators accountable. Considering these complexities and nuances from locale to locale and context to context, any kind of toolkit approach to transitional justice, according to which roughly the same measures would work equally well everywhere, becomes impossible. These reflections can also lead to the foundational question if transitional justice measures should be established in post-conflict settings at all. So do we need transitional justice? And if so, what kind of transitional justice measures do the concerned people envision? Basically, who wants what type of transitional justice and when? This is, of course, also a fundamentally political question. Power politics are certainly involved when considering whose priorities take priority in dealing with the violent past. This we shall keep in mind when turning now to the Somalia case study. So now I will talk a little bit about the history of violence in Somalia just as an overview, and then about the results from this research on transitional justice or conceptions of transitional justice. In a nutshell, the political and normative orders in Somalia today are influenced by complex layers of large-scale violence. We can distinguish four broad phases of mass violence and gross human rights violations in Somalia. The first one would be under the presidency of Mohammed Siad Barre between 1969 and 91, which also involved guerrilla operations against the regime and its supporters. The second phase was under the so-called warlords in the 1990s. The third phase was under the Islamists from 2003 to until today. And this third phase, which kind of runs through the last decades, actually concerns international interventions in Somalia, mostly by UN and US forces between 1992 and 1995, by Ethiopian forces 2006 to 2008, and African Union mission forces from 2007 to the present. Each of these phases has its characteristics of violence and human rights violations and involves partly different, partly similar perpetrators and victims. So I will not really go very deep regarding these phases of violence because I think most of you have a basic understanding of them. Just in a nutshell, state violence in the 1970s and 1980s basically involved the security apparatus and the military against civilians. It involved large scale, it involved, so to say, the normalization of torture, of abductions by state agents, but also gross human rights violations and mass violence in the late 1980s, particularly against civilian populations in northern Somalia, but then also massacres, large-scale massacres by security forces of civilians in Mogadishu, for instance, end of the 1980s. So it was basically state against civilian actors, but it also involved, of course, guerrilla forces who also committed crimes against either state agents or also civilians who were considered supporting the regime. So this was basically the phase late 1970s and then throughout the 1980s. Then in the 1990s, you would have the period of warlordism and civil war. You had a large part of the population which was armed from 1991 onwards. In this context, however, social hierarchies became particularly relevant. So those who were hardest hit by the violence in Somalia in the 1980s were women, children, and members of minority groups who suffered looting, enslavement, sexual violence, and killing with impunity. Hundreds of thousands were killed directly or indirectly by the civil war, including the famine between 1992 and 1993. Also, the horrible individual suffering is relevant up until today. I mean, if you hear heard the stories of Somali asylum seekers in the early 2000s, for instance, which I heard as an expert in several court cases, you would hear really horrifying stories of individual suffering of people who have been enslaved for years, who have been sexually enslaved or otherwise enslaved, put to forced labor in southern Somalia by various militias over many years. I mean, these kind of histories of individual traumatization, multiple traumatization are still around. I mean, nobody ever dealt with them. So you have people who are 30 or 40 or 50 years today who have been multiply traumatized, and this has not been accounted for. And this all goes back to the violence in the 1990s mostly. And then, of course, from 2003, 2004 onwards, you have the militant Islamists coming to the fore in Somalia, mostly in southern Somalia. The Union of Islamic Courts took control of Mogadishu in June 2006. It was evicted by an Ethiopian intervention force in December 2006. But then from early 2007 onwards, Al-Shabaab was emerging as a relevant political actor on the ground. And ever since, up until today, Al-Shabaab is actually fighting the Somali governments and their allies. And this fighting includes also classic guerrilla tactics, but also tactics like suicide bombing or the intimidation of local populations, harsh corporal punishment of criminals or those suspected of supporting the government. So you have a whole period of extreme violence in southern and partly central Somalia since 2007. With many victims of particularly suicide bombings and similar indiscriminate attacks against civilians in Mogadishu and other places. And then, of course, one should not forget, as I said already, you have international intervention forces who have been on the ground in Somalia since 1992 and who have committed also horrendous crimes against human rights violations against Somali civilians. Starting actually with the UN and US Blue Helmets or peacekeeping forces in 1992, 1993, but also continuing, of course, up until today under, when the AMISOM, the African Union troops, entered Somalia in 2007, for instance, they were actually quite unprepared for the attacks of Al-Shabaab, and in reaction to any form of Al-Shabaab attacks in Mogadishu, for instance, they were starting to shell whole neighborhoods and basically used indiscriminate violence in which many civilians were harmed. Though some of these things are documented, but they have never been really accounted for on the ground. So this is basically the context of violence in Somalia over the last 30 years, which is still relevant today. So what about the legal context? So Somalia can be characterized as a classical legal plural context. For centuries, actually, Somali customary law and Sharia have been existing side by side in the Somali Peninsula. With the introduction of colonial state structures in the early 20th century, statutory law began to play a role. It did not achieve a dominant position well into the mid-20th century. Only with the independence in 1960, the overall political framework, including the legal system, was dominated by the state. So I would argue the state took hold in Somalia only from the 1930s onwards, so pretty late. And within 1960, you had a certain period of, so to say, dominant state politics, including a statutory legal system. Particularly under the government of Mohammed Siad Barre, the state institutions penetrated also in the rural hinterland. Yet, despite the relative strength of the state in Somalia in the 1970s and early 1980s, Somali customary law and Sharia always played a role for dealing with legal issues, but it was a subordinate role until the late 1980s. This changed dramatically with the collapse of the state structures from 1991 onwards. Over the past 3 decades, state institutions have been weak or even irrelevant for most Somalis. More recently, with the establishment of the Somali national government in Mogadishu in 2012, state institutions, including the judiciary, became somewhat more stable again, yet today still the majority of Somalis, including people in Mogadishu, do not fully trust the state to take care of their issues. Therefore, the current situation of legal pluralism in Somalia is characterized by a non-hierarchical coexistence of statutory, customary, and Sharia law. All 3 can be characterized as semi-autonomous legal fields in the sense of certified more, coexisting, influencing each other, but without one clearly dominating the other. Only one qualification, only one exception, so to say, or one speciality is that the statutory law in Somalia, in my argument, is the weakest form of law. Conceptions of justice vary between customary, Islamic and statutory settings. Strong compatibilities concern the status, strong incompatibilities concern the status of women before the law and the type of sentence issued. Under customary law and Sharia law, women are treated as second-class citizens in many regards. While under Sharia, women have their rights, these rights usually are inferior to those of men. However, women can defend themselves before Sharia courts if they wish to do so and receive direct compensation. In Islamic law also guarantees women their share of inheritance, which, however, is inferior to that of men. Under customary law, women are represented through their male elders and their concerns are heard indirectly. Compensations for wrongs are usually received by male relatives of wronged women. Women themselves rarely have influence on decisions and, if wronged, only receive a small amount of personal compensation. Traditional inheritance rules disenfranchise women. Under statutory law, men and women enjoy equality, in theory at least. This also concerns inheritance, and it goes against Sharia provisions. This goes against Sharia provisions which had caused protests in the past. So when actually the Somali family law was introduced in 1975, which was inspired by socialist ideals and the equality of men and women, famous sheikhs revolted against this law because it was contradicting Sharia. The whole problem, another problem in Somalia in general, is also that minority groups are generally marginalized under customary law and also in practice, at least, under statutory law and Sharia law. Judicial processes also differ between the legal orders. Regarding customary law, older men play a decisive role. They must know Somali traditions, also the preceding traditional cases under traditional law. They must know social relations, social traditions, and so on and so forth. And younger men and women are normally excluded from the proceedings under Somali customary law. In Sharia, under Sharia, Islamic scholars take the decisions. Their principal expertise is knowledge about the Quran and the Sunnah, and the discussions and interpretations of Islamic jurisprudence. They are all men, but their age difference doesn't really matter so much. But women would never become judges in Sharia courts. Under statutory law, men and women are equal in theory, but actually, and the Somali constitution says that all laws in Somalia must be in accordance with Sharia, so women would never be judges again. So the access to justice is quite different in urban and rural settings. Countryside dwellers usually have only access to customary law. Sharia and statutory law are available mostly in urban settings. And members of minority groups, however, are structurally excluded, and the urban poor cannot afford proceedings under statutory law, which is normally quite expensive and involves also a lot of bribe paying, and so on and so forth. I mean, the whole aim of this section was actually to show that, you know, in this plural legal setting of Somalia, different proceedings are in place, and different, say, social hierarchies in Somali society play out differently regarding to access of justice. Now I would come to this part, which is based on interviews conducted in August and September 2021 in the context of this consultancy initiated by the Somali Stability Fund. So one big question concerned the demand for transitional justice in Somalia. So is there a demand for transitional justice in Somalia? What did the interlocutors say? The majority of all respondents stressed that the past violence and injustice should be addressed. Participants felt that this has to be done openly to stop the cycles of constant insecurity and instability in Somalia, which mainly relate to unsettled bills of one group or one person against another. So an interesting aspect was that, referring to these layers of violence in Somalia, many people noticed that, as long as all these complexities of violence in Somalia have not been addressed, they breed new violence. Though the current violence in a way goes in a complex way related to many forms of past violence in Somalia. So there was a strong sense that, the past violence in Somalia has to be addressed in order to achieve stability and peace in the midterm future. Some added that according to Islam, every person is responsible for their deeds. And if people would fear Allah, they would voluntarily admit their bad deeds and ask for forgiveness. Many also hinted at the fact that the reality is different, that indeed many well-known perpetrators hold powerful positions and are seen as heroes by the respective patrilineal destined groups, pointing to the likely political obstacles to come into the way of transitional justice. So, one thing is, for instance, that quite well-known warlords by now have joined the Somali government in Mogadishu. They either are members of parliament, or they are advisors to certain high-ranking politicians, or they have some kind of special roles to play in the current Somali government. Several people referred to examples of dealing with a violent past elsewhere in Rwanda, Liberia, Sierra Leone, and they said something similar should be done in Somalia. However, the problem was that stable state institutions have to be in place in order to initiate transitional justice effectively. Some respondents also mentioned that it was better to forgive and move on without detailed investigations into past wrongs and potentially long trials. Some mentioned the Somali concept of halai dalai, which means literally born yesterday or last night, meaning without any crime. So basically a newborn baby hasn't committed any crime yet. So halai dalai means we should actually consider each other as newborns and move on without thinking about what every person has done in the past. Though, in a nutshell, basically, regarding the question, is there a demand for transitional justice in Somalia? I would say yes. Many people said the past violence has to be dealt with. There were, of course, all kind of also several voices who said we should forgive and forget. But I would say most respondents actually said we have to find some way of dealing with a violent past. So the next question concerned what justice actually would mean for Somalis. Respondents emphasized that justice is when people's rights are respected. Numerous respondents also related the concept of justice to Islam and said that fearing Allah provides the basis for justice. Most respondents stated that currently and for decades now, there has been no real justice in Somalia. No one of the respondents went back beyond 1991. So all the crimes which people were concerned about were happening from 1991 onwards. But I guess this can be explained by the fact that the respondents all came from South and Central Somalia and not from Northern Somalia, where, of course, many crimes have been already committed in the 1980s. Though the respondents argued that the absence of strong state institutions today prevents justice to be done. Interestingly, traditional ways of settling conflicts were only in very few cases mentioned related to justice. So while customary law in Somali, which is called her, is very prominent in dealing with conflicts at the everyday level, most respondents did not mention her in relation to justice. So her was just providing practical solutions for immediate issues, but it was not seen as an appropriate legal form to deal with a violent past and really to provide justice. There's another form of justice which some people invoked, which is the justice in the hereafter, based on divine law. So if people were really devoted to Allah, they would only, so to say, they would fear Allah, they would watch what they were doing in the world. And quite a few people said that the only justice which we can reach will be in the hereafter. So basically saying that in this world, and whatever we do, we will never achieve justice. Some women also demanded rights, the equal rights with men, which were not in all regards in accordance with Islamic provisions. So this tells you that there's a certain tension in the Somali society, as represented at least by this sample, where on the one hand there was a concern that actually the statutory system is so weak that no one really would expect justice at the moment from any kind of state institutions. Also, not many people were expecting justice from customary legal, from the customary legal systems. Most people were actually trusting Sharia as a way to achieve justice, but also within Sharia, of course, then there were discussions, for instance, between men and women, who has what kind of rights. So the next big question concerned what already has been done to deal with a violent past in Somalia. And most respondents said that nothing has been really done to address the past violence. Some mentioned that through customary legal proceedings, some disputes had been settled, some had received compensation for killings or other violations. But they also emphasized again that Somali customary law only provides ad hoc solutions at the local level and doesn't really help to establish larger national agreements regarding, for instance, dealing with a violent past. Under Hoehne, also many people said that Hoehne actually, the customary law, it only provides, so to say, pragmatic solutions. It also disenfranchises, of course, women, it disenfranchises minority group members. If you want to put it another way, Hoehne or customary law considers real political power differences between actors, which means that weak actors always get not a very good deal. A sheikh from Mogadishu outlined that Hoehne doesn't do any justice, it's only about compromise. Women also would say that men benefited from Hoehne and women wouldn't benefit from Hoehne or from Somali customary law. This example of, for instance, sexual violence was given by several interlocutors, that if a woman has been raped, under customary law, the compensation would largely go to her male relatives, and the victim of the sexual violence would receive only a very limited amount of compensation. The next big issue was what violence needs to be addressed, what kind of, what of the crimes, which kind of crimes need to be addressed. The most prevalent crimes mentioned in this research, like from last year, were actually were property crimes. So looting and the violation of property rights was actually a main concern. And the second concern was sexual violence. So all respondents agreed that property should be returned to its lawful owners. Several respondents distinguished between movable and immovable properties. The latter, for instance, land or houses should be returned. The movable property, like animals or cars, should not be returned because they have been used or lost or otherwise have become useless over the years. The majority hinted that the challenge to providing legal ownership through documents or witnesses is huge because most of the property documents have been lost over the course of the Civil War. Some argued that many, again, regarding killings or other violent crimes, including rape, many argued that the number of incidents over the past decades was unaccountable. A female NGO worker from Mogadishu, for instance, stressed that it will be nearly impossible to go after all the perpetrators of sexual violence and hold them accountable. Others would say many of the victims, but also the perpetrators have died in the meantime, so there's no point about dealing with this form of violations. Another thing which I would add, of course, is also the stigma which is attached to sexual violence in Somali society, where the victim of sexual violence is very often, so to say, held responsible for what happened to her. Then the question of individual accountability. Most respondents stressed that the perpetrators should be held accountable individually and that collective accountability under customary law is not enough. So another interesting aspect of hell, of course, in contrast to Sharia, is that under Somali customary law, normally groups deal with each other and individual perpetrators are covered or more or less by their clan. But under Sharia, of course, individual perpetrators can be held accountable. Some argued that those who have committed a crime shouldn't be allowed to hold political office. This is a classical transitional justice mechanisms. It's called vetting, which has been used in many Latin American contexts. For instance, that people who have a track record of past violence will not be eligible for any kind of political position. Also, if you look at the German history, this should have been actually the case after 1945. We all know many former perpetrators from the Nazi regime held political office after the Second World War. So people argued that without individual accountability, there wouldn't be any stability in Somalia in the future. However, numerous respondents mentioned the obstacles for that and argued that to hold perpetrators accountable, you need a strong justice system. They pointed out that in order to establish accountability, you have to have a certain due process. Facts need to be collected, evidence needs to be established, and without due process, you can really not hold individuals accountable. Some mentioned that those who are supposed to judge are partly themselves perpetrators. Or also in the security forces, you have lots of perpetrators who are hiding and who are now policemen or part of the Somali army. Several respondents stressed that only if all perpetrators, meaning from all clans, could be held accountable, one should push for individual accountability. Well, this is another dilemma which I think is a little bit specific to Somali society, which I encountered in many instances, that people would argue it's useless to hold 1 or 2 or 5 or 10 perpetrators accountable if we cannot hold everybody accountable, because if you hold 1 or 2 or 3 or 5 perpetrators from certain groups accountable, the discussion in Somali society will not be about the individual crimes committed, but the question will more concern from which patrilineal descent group are they. So if, Mohammed from clan X is put on trial, but Ahmed from clan Y is not put on trial, then the question very often boils down to the question of clan belonging and clan rivalries. So community leader from Mogadishu cautioned that the political balance in the country at the moment is so delicate and can be easily unsettled by such kind of processes. He said we need to be cautious. It's good to hold perpetrators accountable, but considering the fragile situation of Somalia, we need to forgive and ignore, because by holding the perpetrators accountable, we might put the country into more trouble. We should rather advise them to seek forgiveness from the community they have wronged. So this, in a way, is also a reference to the Islamic concept of asking for forgiveness. However, an active Al-Shabaab member argued that it's important to hold the powerful figures who today influence politics in Somalia accountable. So, what are the obstacles for transitional justice in Somalia? Most respondents outlined that clanism or clan favorism and the lack of stable government institutions are the biggest obstacles to deal with the violent past in Somalia. Many argued that at an individual level, most former perpetrators would seek to prevent investigations into their crimes. Some hold powerful positions in government, but also in a few cases as traditional authorities. Respondents repeatedly mentioned that those who committed crimes against former enemies are considered heroes by their own group. So this is another phenomenon which I encountered actually over the years many times, that, so to say, the killers of one group are the heroes of the other. So the challenges or these obstacles cannot be overcome without stable government institutions. So to say, to open up these questions of individual accountability before stable government institutions are in place would actually destabilize Somalia further. So now I would come to the last point before the conclusions. before the conclusion, the question of forgiveness and repentance. Many respondents highlighted that forgiveness is a strong value in Islam, yet it's not without condition, and it's not clear to if one always has to forgive. So the respondents were divided on this question about forgiveness, and many mentioned that forgiveness would be the right thing for different reasons. Many referred to Islamic provisions, while others stressed that it was, under the current circumstances in Somalia, impossible or dangerous to hold perpetrators accountable. Those advocating forgiveness did not do so unconditionally. They mentioned that, in accordance with Islam, before a perpetrator can be forgiven, he or she must admit his or her crimes and repent. Some also stressed that it was for the victim to decide if a perpetrator should be forgiven. An equally large group of respondents emphasized that perpetrators should not be forgiven and should be held accountable, to say, and put to their punishment. Related to this question, I would say, of forgiveness is also the question, should the past be remembered? So this is, of course, also a foundational question regarding the whole process of dealing with a violent past. And interestingly here, I would say very strong contradictions became visible, because many people actually said that, and also again referring to some Islamic provisions, that remembering is not very healthy, that remembering causes emotional pain, that to constantly remember makes people sick, actually. On the one hand, you have a demand for accountability, you have a demand for establishing the facts about what really happened and hold individuals accountable. On the other hand, there is this idea of, forgiving each other for Islamic reasons, but also for pragmatic political reasons. And then there is this other idea of, not remembering what happened because it's too painful and it only prevents individuals from moving on and actually surviving. So I think I come to my conclusion here now, that this research didn't provide any kind of clear-cut solution. I think I tried to outline the complexities of the Somali case, the complexities of these long histories and multiple layers of violence. I also tried to outline, so to say, the problems or the tensions, I would say, which arise from the non-hierarchical legal plural setting which is prevailing in Somalia over the past 30 years. And I think I also wanted to highlight in my conclusion now these contradictions which were voiced by many of the respondents of this study last August and September. And I think these contradictions are quite normal in a plural legal setting, where also the conceptions of justice and of due legal process really differ quite a bit, let's say, between international legal norms, customary legal norms, and Sharia. So I think that there's a real demand to continue this type of research, or to continue this kind of reflection on the place of Sharia in transitional justice processes, because one clear result from this research on transitional justice in Somalia is that, of course, Sharia is considered by almost everyone the most relevant body of law. So, Somalis would always refer to Sharia, even if there are contradictions between what women want and what men want, and between, the practical applications of Sharia, between, let's say, majority groups and minority groups. There's lots of contradictions in everyday life, but I guess most Somalis could agree that justice can be achieved if Sharia is applied. I think in the established literature, which I outlined at the beginning of my talk, there's very little reflection on the place of Sharia in contemporary transitional justice processes. And I think this is an interesting gap in the literature, which can be filled to some degree, or which should be filled. Okay, thank you. This is the end of my talk.